Hey, everybody. Welcome to IMMPact Litigation's weekly immigration litigation update. I'm Chuck Cook. I don't have my name on here. I should put my name on there.
Everybody knows who you are.
We have Greg
no idea who you are.
and the other attorney on with us.
Yeah. Why is my name on there?
You should just write other attorney.
I'm trying to actually. I was trying to do that.
That would be classic. Just put other attorney on there. So we have some fun things to talk about today on our litigation. Of course, we want to start right off with the EB Wasteage Delay case. We are adding plaintiffs at this time to amend our lawsuit later this month. If you'd like to be part of that effort, you go to this website right here and you can sign up. We did have, by the way, our first person approved, right?
We've had a couple, and we actually, well, I won't say who it is, but there's an important plaintiff that just got her approval.
Amazing how the plaintiff's name get approved like that, right? It's congratulations to them as well. So if you're welcome to join us, but gentlemen, this lawsuit, I think it had an impact over in Maryland at the USCIS headquarters. What do you guys think?
I think so, and I don't think it was just the filing of a suit. I mean, we broadcasted pretty loudly. We even told them what day the suit was going to be filed on there, even though we were a couple hours late.
Well, did you notice that the Friday before, the Tuesday we were filing it, they came out with an announcement?
Yeah. No, we know that the litigation is not ignored, and we'll see.
All right. Now, Aaron, you were noticing something with these numbers, Jesse, with numbers that came out. So last Friday, a week after their last announcement saying, we're going to use all the numbers. Thank you very much for that great litigation language. But they came out and they actually gave us numbers for through the end of May. What have they done so far?
Yeah. So they said on Friday night that they've used 149,733 employment-based immigrant visas through May 31st, 2022. And, again, they use the strongest language possible to say they're committed to taking every viable policy and procedural action to maximize their use of all available visas by the end of the fiscal year. Now, if that's true, we should get a phone call any day now, because we have some great ideas, I think we've put together a package of great ideas to solve this, is a self-made crisis by the government, right? Mm-hmm. And everybody seems to want to do the right thing for our plaintiffs and putative class members, and I think there's a way to get to the goal line here. And I know that we've talked in maybe half-heartedly about, like, oh, come talk to us and we can explore. Well, we're doing that. We're trying to do that. But at the end of the day, there's 100,000 visas or so that would need to be on an accelerated pace here before we get to 10-1.
Well, we don't know how many they issued in June, but May 31 is 2/3 of the way through the fiscal year. And 2/3 of the way through the fiscal year, they used about 53% of the available visas. So they would have 4 months, one of which has already passed, the other is halfway done, to use 131,000 EB visas.
Yeah, and I'll raise a good point. John Wasden, who he's shy, won't get on the call lately, but he made up a great point that if they were doing this under their stated policy of first in, first out, we should not see so many 2020 and 2021 applicants. They shouldn't be out there, and yet we know they are.
Well, 50 of our plaintiffs are there.
Exactly.
So it's crazy.
Well, the whole thing about reserving visas would end the crisis, because then they don't have to worry about being in this mad rush and pushing all these resources to just working on these kinds of cases. They can get to them as quickly as they can. But, they have had the case laid out for them for at least a year and a half, as far as the legal case made out for reserving visas and how they can look at it. This is not something, and I remember talking with lawyers at DHS about this, and who had said, we've gotten memos that explain, how we could do this. And there is an internal debate that's going on. and we'll see how things shake out. This is a year and a half ago. Obviously, they didn't shake out the way we would like, but the point of it is that this was not something that was like black and white, that they had to, they try and take this position. It's like, we don't have a choice. Our hands are tied. We have to do it this way. This is what the statute says. And that is simply not true. The statute, they have been presented with pretty good legal arguments from pretty smart lawyers on how they can do what they want to accomplish from a policy perspective without violating the law. And that's the question I think we're at this point, which is, this is not a legal question anymore for USCIS. This is a policy question. They have the law on their side if they want to take the case that they can reserve visas on there. Anybody at the agency who says we don't have a choice in the matter, they are basically defending a policy choice that they're making. And it is not there are plenty of people at the agency, there are plenty of people outside the agency who can make a very strong case that the law allows them to do this, and they don't need a judge to order them to do this. I think some people at the agency would like a judge to order them to do this, because then it takes, then they can say that they don't have a choice in the matter on there. But the law is on their side if they want to do the right thing here.
Now, I do want to point something out. Even though immigration came out on Friday night and said, hey, through the end of May, we've issued this many immigrant visas, what the USCIS has not done is publish their second quarter numbers. We still don't have second quarter numbers for them anymore. We don't know what they are. But if we look at the end of the first quarter numbers, as of the end of the first quarter, USCIS had pending in their offices 253,000 employment-based adjustment applications.
Oof.
At the end of March, they had not used about 240,000 employment-based immigrant visas. They literally could have almost literally zeroed out all pending employment-based adjustment cases that they had pending. They could have zeroed them out by the end of this year. Now, obviously, we don't have the newest numbers. We don't know how many have been filed, et cetera. What we do know is this: they are not first in, first out. I mean, I know that for a fact because one of our clients filed an employment-based adjustment application in March and was approved in late May.
Well, how could they, Chuck? They move these cases from place to place. Like every couple of weeks, they ship, hundreds of boxes or thousands of boxes off to another location where supposedly they have more manpower to do it quickly. There is no system for moving all these cases.
The other thing they do, which is crazy to me, and I've seen this in a number of cases, they split the principal and derivatives, right?
Oh my God.
And so,
that's what just happened to our very important plaintiff yesterday. I don't know if Jesse's seen that. I know, Chuck, you've seen that about it, but she has she got the approval and we have no information on the spouse.
Yeah, I've seen this. I mean, I've actually had individual clients on other cases and where we've raised this and they're like, oh yeah, I guess we they settle it, but it shouldn't be happening though. It should not be happening. And sometimes we're at two different service centers.
Oh, or different offices. I mean, one could be in Texas, one be in Atlanta. It's absolutely insane.
The thing about first in, first out is I know that they cite to it a lot. They say that they follow this in their cases, and we know that's not true. I think the thing that nobody talks about is it probably doesn't make sense for them to do a very strict first in, first out. It would be too much effort to organize it that way so that it's strictly first in, first out. But we just need to acknowledge that reality. It can be roughly first in, first out, and they can admit that it's not. But when they come into court and say we do it on a first in, first out basis, it's just not true, and we know that.
Well, nobody, if you're a couple months off on this, nobody's really going to care.
Right.
But when you're adjusting people who applied in March 2022, and you have pre-October 2000 people in the exact same category that have not been adjusted, that's morally wrong. I mean, that's just morally wrong. But I keep focusing on this. They have enough applications on file to use all the numbers. They've had that for 9 months to do that. And yet, although we haven't heard recent begging from them, please file AB2 cases. Maybe they fixed that crazy interpretation they were trying to force down the throats of folks.
I doubt it. I think that's going to be an excuse when they don't use up the numbers at the end, saying we asked you to do this and not enough of you did.
and yet all the Indians are going, what word am I, Swiss cheese? So why am I not getting approved? I'm an EB2. I don't understand. The other thing we haven't seen is any movement in visa numbers.
Yeah.
We're approaching the end of the year.
They're not getting enough applications. There's one easy way to fix it.
So we'll see. And if they, that's the other thing. If they had on file enough applications, they need to keep that pipeline full, because next year, generally speaking, as I understand the visa bulletin, maybe you can correct me, Greg, that visa bulletin is you will be, if you're current, you will be adjusted within 12 months, is my understanding of how that works.
That's right. That's how filing dates work.
Right. So that's how filings are supposed to work. So if you have enough on file and you're going to use them all, why isn't that date moved forward? I mean, that's the crazy thing for Indians.
Right. If they have enough pending adjustment applications because their forecast was really wrong from the year before, then they should not be moving the filing dates.
Yeah, and the other thing they did mention in their, they finally acknowledged in their memo of Friday night, yeah, there's 85,000 EBs we didn't use last year.
Yeah,
85,000 people did not get their green cards because they didn't do their job. And
they could use the Cyrus Mehta theory on filing dates, whereas if one number is still available, everything should be current.
I love Cyrus.
Right? That's the best. That would be the best. That would be an agency. If they did that, that would show me that the agency was really trying to be creative to make themselves really a service agency.
Interpreting the law in the light most favorable to the foreign national.
Right.
I think the Supreme Court has said that several times. So that's kind of where we are. If you want to join as a plaintiff, we'd love to have you. We're going to be updating that later this month. We're also in the midst of preparing our preliminary injunction in this case, along with class certification. Somebody reminded us, why aren't you guys filing anything yet? Well, we're working on it. This is the kind of stuff that takes a little bit of brain power, a little bit of time to get done right. The judge that we were assigned is a senior judge in the Western District of Washington State. Just in the last couple of years, he enjoined a couple of Trump's immigration policies. He is a Reagan appointee. Give me an idea.
Reagan was great on immigration, so
Reagan
I have no
was great on immigration. And this guy's great. I mean, he's got some really good immigration opinions out there. So
Reagan.
But he might be younger than the judge we had in Maryland, although I'm not sure. He could be older than that fellow in Maryland that we had. But I think I'm happy with it. We got a good location, and that's where we are. Anything else you guys want to add on this particular issue?
Yeah, I mean, I think on the PI, the preliminary injunction, I mean, it's also to everyone's benefit to let the government digest what we put on paper, right? And so that is because when you file for a preliminary injunction, you're really putting yourself and the judge and the government on an accelerated pace. And as we know, the government is slow, right? And so giving them a couple of days and weeks maybe to digest what we put and maybe come to us with an agreement in place, it could be to everyone's benefit. I'm not saying that's going to happen, but it would, it actually is good to maybe take a pause, right? If you want to file for a preliminary injunction right away, you're probably better off filing for a temporary restraining order. And this is getting too complicated, but I think the calculation here is the right one, which is give it a breath and then go.
Yeah, I agree. We're in good shape there. And we will be sending out an email to our plaintiffs in that case once a week to keep them updated on the status of the case. So you'll get an email later this week to let you know what's going on. Nothing. It's going on right now than what we just talked about. All right, Aaron, I want to feature you for a second in the Kang EAD case because we're doing something there.
Sure. Yeah, we are waiting on a ruling from Judge Leon on the motion to dismiss still, and some of you might remember that he had requested a supplemental briefing on mootness, basically saying, "Hey, isn't it? Is there a chance that the fact that none of the named plaintiffs have live cases anymore, shouldn't I just dismiss this case?" And the answer is no for a lot of reasons. So that was briefed by both sides, and then we are actually filing today a notice of supplementary authority with some cases both from the Supreme Court and then also a case that Jesse had worked on. We want to highlight and make sure that the judge sees that and sees that that there's no reason to dismiss this case.
So we'll hopefully that will kind of be an impetus maybe to get a decision going forward. Going good. All right, good. Thank you so much. I do want to talk about this for a second. Greg, you had tweeted out some great information yesterday about Ukrainians and employment authorization documents. What's going on there?
So one of the coolest things that this administration has done on immigration, and I've heaped a lot of praise on them, is the Uniting for Ukraine parole program. It was really, I think actually it sort of stems from a David Beer idea from David from Cato from a long time ago about individuals being able to sponsor people to come to the United States and basically having a refugee program that was much more flexible based on that. So they actually did that. You file online for Ukrainian. The requirements are very reasonable. Basically, it's an affidavit of support that the U.S. sponsor fills out, and they are getting these things approved in weeks. Like the first ones that I had were like less than a week that it took them to get approved. And these people are coming to the U.S., which is great, and they're being welcomed in these communities, and that's all going really well, except for the fact that these people are not going to be able to go back to Ukraine for a while, and a lot of them would really like to work, even though they're not going to starve because they have sponsors in the U.S. For a lot of people, work is important to their psyche. It's important also. A lot of times they're sending money back to their families. They have a lot of reasons why they need to work. Plus, we need the workers in the U.S. We are 3.6% unemployment. That is 0.1% off the all-time record low unemployment in this country right now, and every industry is feeling the shortages. So when they get here, they have the USCIS says, well, you have to file for a work authorization document in order to be able to work. And by the way, the C11 category you have to file under, because we're telling you that's the category you have to file under. That is taking 9 months at the location. I think the National Benefit Center is where all those applications are supposed to be filed. So that's not great. And USCIS has been complaining, loudly that they are getting all this humanitarian work piled on them, that they have and that's slowing everything else down on there. So the Congress in May passed some very boring sounding bill called the Ukraine Supplemental Appropriations Bill of 2022. It sounds like it's just money, but it's not. There's an important section in that bill that deals with Ukrainian parolees, and it says we are going to, if you enter the U.S. after February 24th or 22nd, I forget the date, as a parolee from Ukraine, you're to be treated as a refugee, and that means you're entitled to, under the Section 207 refugee section, all of the same benefits that are available to refugees. So one benefit that we talk all the time about benefits adjudication at USCIS. Probably the most important benefit for people short of a green card or citizenship is the employment authorization document that USCIS will adjudicate. So I remember when this bill passed, and I was thinking that we were going to be getting I figured let's give USCIS a couple of days on this, and they should be announcing how they are going to change their procedures so that Ukrainians no longer need to have a work card in order to be able to start work, because refugees don't have to have a work card. They're considered able to work incident to status. And the way it works for refugees is they have an I-94, and that's all they need to present for the first 90 days. And then they're expected, by that point, they can either have an EAD card, which they can use to show work authorization, or the handbook says that they can get a driver's license and an unrestricted Social Security card, which Social Security Administration is also, I believe, will give you an unrestricted card as a refugee to work. So it's a neat solution that means that refugees in most cases don't ever need to have the work card on there. Well, 2 months have passed almost. I think today's the 12th. This law passed on the 22nd of May. And not a peep from USCIS about this, and it's almost as if they didn't know that this law passed on there, which I find hard to believe. But I'm not sure what conclusion to draw at this point. So there were two issues. One is, like, why are you not treating these people like refugees if the law says treat them like refugees and give them the same benefits on there? And two, why are you charging for the EADs, it says in your, in the regulations and in this form, it says you don't charge for I think it's C3, the category that 207 that they are supposed to be treated as Section 207 refugees. You're still charging these people who have no money in a lot of cases because they basically haven't worked in weeks or months. They had to flee their homes. They had to get to the United States. There's like a million things that they had to spend money on these. And now you're saying, oh, spend $410 on top of that for a benefit that Congress says you don't even need on there. So it's just bad. And I'm hoping that by calling some attention to it, that maybe USCIS will get on the stick about this. I can't imagine what their policy argument is, why they would want to force these people to have to get EAD cards, except to say that they think they have to do that, even though Congress just passed a law specifically on this question that says you don't have to, and we don't want you to.
I think that'd be the kind of lawsuit you would file with a motion for summary judgment. I
said it in the tweet. It's like, good luck making the case to a judge when all the plaintiffs have to do is just attach a copy of the new and the new law that just passed and say it says this. What is what the plain language couldn't be any more plain than says that they're supposed to get the same benefits on there. So they didn't define benefit in the statute. And if USCIS wants to go down that road saying our benefits are not really benefits, then good luck to them. But I don't think that's going to work on a judge.
Well, you mentioned something else. They should be refunding this money.
Yeah.
And if they don't refund the money, well, there's a place you can get that done too.
Yep.
We're happy to pursue that on behalf of people.
We are, yeah.
Keep folks surprised.
That might be a good entree to the other case that I'm working on with Jeff Forney and a couple other people.
Now, our friend Jesse does have to leave here in a few minutes, so I want to. Wow, there's 39 comments on here. Oh my gosh, I'm not sure we'll get these all done. But Jesse, I know you got to leave when you got to leave. Just do it. All right.
I will.
And tell your wife we said hello. Do you think the Seattle court will allow class action and class-wide preliminary injunction due to the recent Supreme Court ruling? Yes.
Which one?
I mean, recent Supreme Court ruling.
Yeah, and I should say, with respect to Brad's suit, we are not in competition on there. We will be very happy if somebody gets a win before we do on this particular issue. We will be on the sides applauding.
Yeah, I mean, I think too. I mean, yeah, that's a great point, and it really is. It's really two ways of going at the same thing. I think for the class action, we wanted to do two things. Number one, we wanted to make sure that everybody who fits within our definition of a class is protected, and that's important because we're trying to create a move to reserve visas in that under the law, and so there's a class of people who could benefit, and so that's the object there. I mean, but ultimately, what these measures are not really about the merits of the cases, but really about how or front running the government's attempt to maybe split these apart like they did last year. I mean, last year was not a class action. I wasn't part of that. You guys were. But when you run into a rogue government and rogue judge, that type of sequestering or splitting of cases is really a lesson that everybody learned inside these cases and outside. And that tactic is simply not a viable one or not a strong one in a class action, because we do have plaintiffs who reside in the district, venue's appropriate, and we're seeking class action. So there's no other place to split. They may try to do that, but they may try to do that in other cases as well. So again, yeah, it's really not about a competition. It's really about a comfort level. And so, I hope every case wins. It's like DV to me, like diversity visa cases. It's like, I don't care who wins. I just want us to win. Get
it for our clients.
Yeah.
So, Jack Sparrow. So you have heard of me. 60, the government has officially until July 15th or September 15th to respond. This will be resolved and well in front of the court. In fact, Judge Zille has already ordered a status report from the parties in early September. We'll send it out to our clients here, but preliminary injunction we believe will be filed this month. That's our goal. should the government not make efforts to deal with this. So we're serving them right now. I think we get service here confirmed. Probably already have service confirmed. I need to double check that. But as soon as we get an appearance from a government lawyer, we will begin talking to them about this process. So good points. Thanks for bringing them up. Let's see. Rohit, how would papers serve the government start the city response clock in Madhavan? I believe the government has been served. So
Yes.
They have been served. So we're good. We're good on Madhavan. That's the case here we've been talking about. Will we know? You can never know what a federal court judge will do. But it is a defined class. It is a narrow class. It is a class that fits well within class action certification criteria. So I would see no reason why there wouldn't be a class certification. Plus, Northern District of California has great rules on class certification, which we clearly meet the standards of. Why did we choose the Western District of Washington State? Well, because it's in the Ninth Circuit and it's a great location. It's also the home for MDL. So it's a good place. It's a good place to go. You may have noticed a lot of good lawsuits have come out of the Western District.
We actually have a lot of plaintiffs from there too.
We have a lot of plaintiffs from there.
I would recommend, everyone, a lot of these questions are addressed on the IMMPact webpage, and again, it's to everyone's benefit. Never sign up for a lawsuit unless you've read through and consider this. I mean, a lot of these questions are addressed. I try to tell people all the time, like, you have time to consider what's best for you and your family. Take that time and make a good decision. We've tried to do our best to lay out what our case is and what it's not. So I'd recommend everyone just take a look and make the best decision for you.
Yeah. I love this question. People waiting for a free ride class action. Look, a class action helps everybody. And yes, plaintiffs, they're of course going to get adjudicated first. That's the thing. Plaintiffs always get done. Their names on the packet. They're the ones who immigration now has a list of all the plaintiffs. They are pulling your files. We've seen this happen multiple times. They're going to look at can we approve this case and get rid of this case?
And I will say, there's a difference here. You can win without getting a certified class granted, because those are two different decisions.
We have the empirical example of
it's a pain case. That's an EAD case.
So
plaintiffs have had their EADs for months. Already. We're still fighting for class certification in that case, but it's taking multiple extra months to even get to that point with the judge. So, if that happens here, it's obviously to the benefit of the people that actually stepped up and signed up as plaintiffs in the case, where they could be have green cards in hand well before the others.
And I think one of the most regrettable, it wasn't our team's fault, but the DV 2020 case where we had a class certified, but the relief granted is going to be too limited to encompass the entire class. Yet every one of our plaintiffs is now in the United States and has been for 2 years, right? So it's, I think if you're, the free ride, nothing's free, right? You pay for what you get too. So.
There you go. This is a good question, but look, we don't know when the go decision will come down. We believe we're going to win. You need to do what's best for your family. That's the best advice we can give you here. You do 100%. What's best for your family. If you've got other options, you should explore them. Last Friday's announcement, USCIS, they're prioritizing. How do they prioritize all? That is the $1 million question. How do they prioritize them if it's every case they have pending? Here's what I think they mean. They mean taking people off of EADs, taking people off of H-1Bs, taking people off of EB-1 adjudication, people off of family cases. Remember, in our open forum, Erd Shadu said they're sending tens of thousands of cases to local offices who don't really have experience adjudicating employment-based adjustments. They're NATs and family people.
Another thing they did in that update, if you read it, it's they say that their published processing times will be extended, but essentially they're made up because there's a mad glut of cases. So it was almost as if they were, although there's real world implications because you really can't make an inquiry about your case until you're outside those processing times. But they basically said, they're going to look like they're vastly extended, but that they're not true. They're made up right now, just given the flux of cases we have. So I don't know what to make of that other than. I think it confirms what we all suspect, which is processing times are literally made up.
They're unknowable.
They're unknowable.
They're unknowable. I mean,
Yeah.
What did Rumsfeld say? There's the things you know, things you don't know,
Unknowns,
that you don't know, and don't know
unknowns.
things you don't know. That's what we don't. Those are the things we don't know that we don't know. At least they were trying last time. The last processing times, they gave you a 50% number, 90% number. Now they give you an 80% number, which is literally made of that whole cloth. You have, I know for a fact. I mean, I looked this morning at a family-based case, Atlanta. It's 20 months. I know it's not taking 20 months.
Again,
it's just
John and I raised this, and I can't get my head there. So maybe I'll just throw it out to the audience and you guys. So he was like, if they give you that 80%, if they give you a number that 80% are processed in X amount of time, and that means obviously that 20% are not, does that somehow, prove that first in, first out is not followed? That I don't know. I'm not smart enough to figure that out, but that was like a riddle that John had. I mean, he's the brains of the operation, but
for that reason, I would love to take a deposition. Whose job is this?
Right? No, there's no doubt.
I mean, where does this number come from? This is just made up.
Well, and I will say, in our Ed Cooney case, and that's our firm's working on. The judge one of the major things. This is for H4s and L2s for petition delays, where they tried to come in with that first in, first out and get out of here, and the delays are okay. And, we had a kind of a split decision, but in that the judge was really curious about this notion of first in, first out, and the fact that we had seemed to disprove it and is going to allow for discovery, or at least allow us to move for discovery in that. So, pushing back against this first in, first out theory, or, we declare it to be so it is, method of litigating, is on a short life.
It's crazy stuff. Now, Sonny Maida has a good comment here, where they were recommend interfiling, but he says, but they're putting them on hold. But if you just refiled, and yet in their memo from Friday night, it says, will my case be processed faster if I file a second 45? So it's like, no. But that's also not true. It's like everything they do is designed to make their own job harder. It is not Orwellian. It is Kafkaesque in its processing ability. It's like if there's a good decision to be made and there's a choice between a good decision and a bad decision, they will inevitably make the bad decision on processing. It's just stunning to me.
Yeah, I think there's this disconnect from the people who want to do the right thing and then the people who actually need to do the work, because I wish they would talk to them more to see how much hell their lives are on the front lines. Like if you have an interfile and transfer, like how do you get the paperwork and the medicals need to come in? Like they need to make it keep it simple, stupid, the KISS principle. They need to do it. Like that has to, I mean, this isn't just USCIS and I'm not blaming them. It's just like they have a great idea, but practically speaking, they need to talk to the frontline people to see if it will actually work.
It's like nobody talked to people that open the mail or open the emails and make the adjudications. Yeah. Nobody said to talk to these people. They probably know a better way to do this. This is just a thing out there called Six Sigma. Lawyers really aren't in Six Sigma, but every legitimate business in America has used Six Sigma to get rid of the externalities, the crazy stuff, the stuff that bogs stuff down. Apparently, except for the USCIS.
Well, State Department too. And
the State Department, yes. Hire several Six Sigma experts in this area. By the way, our good friend Angelo Paparelli is an expert, by the way, in Six Sigma. He'd be terrific to help them out. Sonny thinks we should sue them on this issue. All I can tell you, I'd sue them just to get a deposition. That would be a lot of fun. But it looks like Jesse's going to get to take that deposition, so we'll be in good shape. Let's see. I'm just going through these. A lot of them are the same. What's new with DV 2022 visas and lawsuit? We're waiting to hear from Judge Maida. Aaron.
Let me talk about that. So the plaintiffs who have not been set for interview or adjudicated have been sending me updates with what's going on with their case, and I appreciate that. They should continue to send updates because those are helpful in our communications with government counsel. So please keep doing that.
And we're probably at this point down to maybe a dozen people.
Yeah.
So, I mean, that's what's happening on our lawsuit. Remember, our lawsuit is not a class action on the DB 2022.
Yeah.
It's just for our plaintiffs.
Well, and in fact, you guys, I have another DB 2022 lawsuit, and I will report. There's some good news today. That the Ethiopian consulate in Addis actually issued a number of interview notices for the first time in months, and a number of our frustrated clients did receive interview notices today. I hope they don't stop. And then I think it was, I'm getting the days mixed up, but like Kathmandu issued 900 interview notices last Friday, so there are a number of just efforts being made, not nearly enough in every consulate, but Simon and I have talked. I think they're going to hit 45 to 50,000 total issued, which again, globally speaking, is unbelievable considering where we were in February. I mean, I know that I have 41 people out there in the world right now who say, Jesse, don't say that because we're still waiting, but we're better than where we were. We're not, but some consulates have turned off. They never turned on the spigot. I mean, it's just ridiculous, but hopefully it's a sign of good things that Addis is on board today.
Well, given the fact that they basically issued hardly any DVs the first 3 months of the year, it's remarkable they're going to be that high.
And for those that say litigation doesn't matter, I can just tell you this. The fact that Addis issued interview notices and they've actually said they're in like a week, 2 weeks, 3 weeks. And, that is totally litigation related. Like they wouldn't be doing that. Like this, the whole thing. And I don't mean it's me. I mean, I know that there are a number of others like Curtis and you guys and others who are in this game that is the fighting for DVs. And that is a reaction because they know they have to go before the judge in August and September and explain themselves.
Jack Sparrow's back. He has some questions about Nebraska. I will tell you that in our open forum, Urchadu did say that they realized that the cases appear to be stuck at Nebraska and Texas. This goes to them shifting the deck chairs in the Titanic. She said they were sending out thousands of cases to field offices for adjudication.
Yeah.
Now,
I've seen that.
Yeah, so we're seeing that happen. We're seeing movement. And again, we filed the class action, which we did not file last year. I never got to that class action part with that judge. We also filed in this district because this is the district that does multi-district litigation. So this is the Western District of Washington. This is where it happens. So we intentionally chose this, but we believe we have the correct strategy here. And this way we get to cover all of our plaintiffs as part of this litigation. All right, let's see. I don't think KCC lets us relocate our case to other countries. This, again, I don't know if they're Russian or not, but that was, again, you have to get a third country to accept you, and they have to request that from the KCC. We've talked about this a number of times before, and that's kind of where we are. Okay. Let's see. That's kind of about one last thing with Bose Gana. EB lawsuit approving recent file application bring down average. Yeah, well, now that Bose is a very interesting analysis. You bring down your overall processing times by doing recent cases.
I haven't heard that, but that could explain how they can play with the numbers because those 20%, that are sitting there from the 2020 cases, they can take them out of the data altogether if they just say 80%. And then they can really get the numbers down by saying, hey, we've got all these cases that only took 3 months to bring down everything else. But yeah, you can manipulate the numbers by doing that. Yeah. I don't know if they are, but they certainly could.
Do you give them that much credit? Do you give them that much credit? I don't give them that much credit. I like to explain this to clients. Immigration is a lot like driving home from work. Some nights you leave at 5 o'clock, go to your home, you hit every single green light. Boom, you're home like that. The next night, leave at 5 o'clock, you hit every red light. Why?
Yeah.
I have no idea. That's how immigration works. I don't know why. Sometimes maybe
variables.
You got on the desk of the employee who took 2 months off, is now back. They have no casework to do. Here's your cases, Bob. And boom, he's ripping through them for a couple of weeks until he gets months behind. And then
or they ship your file off to another service center.
Yeah, exactly, to get done faster. Do you believe the USCIS is telling truth when they say they actually processed? Oh, I don't think they're lying about that. They wouldn't lie. Honestly, they wouldn't lie about that because they know it's going to come up and they're going to have to tell a federal judge that number. So no, they're not lying about it.
I also see, like, we do a lot of work, where we have two different agencies out there, right? We have USCIS and the State Department. USCIS, I actually wants to do the right thing, which I don't always feel that the State Department does. I think USCIS actually does want to do the right thing a lot of times. It's just that they don't know they don't have a roadmap to get from X to Y, and that's our case is really giving them that, and hopefully they'll take it.
The only thing I would comment on that is you make an assumption that there's one opinion at USCIS, when I think in a lot of cases it's just raging debates going on internally over this and that, and that there's not one single opinion about what they want to accomplish. It's all a question of who has the upper hand on any particular issue.
And let's not forget, it's the same thing with the Ukrainian EADs, right? Greg, you and I talked about this. Ultimately the buck stops at the foot of the president. And if he wanted to change this, right, at executive agencies, these are all executive agencies, state, USCIS, he could do it. He could tap the person on the shoulder who's working for him and say, this needs to happen now. And maybe he'll do it.
Yeah, I think of the White House, the issue is that they have some great people from the immigration world that are there that are clearly, I think, would advocate for positions that would be pretty popular with people that tune in to this live stream. The problem is that it's the people over them that are actually making broader policy decisions on how immigration fits into everything else. They're the roadblocks right now between good policy and the president. It's not I think that they've chosen some pretty good people since the administration started that have been in the White House on it. And, it's these inner circle people, I think, that in a lot of cases are the ones that have, we don't know which precisely, but it's at that level that I think is the problem. It's not with the it's not with the people that
I
are.
kind of agree with that. By the way, Sandeep has a brilliant idea here. And we can tell you, Sandeep, we are talking. Thank you for revealing the secret strategy. But we are. You'd be surprised how many big companies are interested or not interested in this. We won't name names. And we do have this invite here that if we win the Gomez case, every one of us gets a case, 6-pack of Diet Coke. So that's good for us there.
Right for me, please.
Bo says 45 application moved to National Benefit Center, 82 is back, and it's stuck there. We're stuck at SRC, now stuck there. Yeah, we know. They move stuff for no reason whatsoever. And it's so opaque. You don't know what's going on. I love people. Well, I subscribe to their email or I go online. None of that reflects reality. You don't really know what's going on. Their front-facing database is an illusion. It's an illusion that's wrong too frequently. So I just don't put much faith into that. Cigar, talking about the PI, go back and listen. We already talked about that a little bit earlier. We don't need to repeat that here. Let's see. Oh, I did want to that's the last of the question. I did want to mention our EB5 Jane for our I-526 case. We are seeking a discovery conference with the judge. We need information from the government. We're filing the request today with the court instead of filing a motion for summary judgment because we don't have enough information to file a motion for summary judgment in 526. We're trying to get the government to approve all our 526s, but for now we're going to seek discovery. Now, another case this occurred in. And they sought discovery and immigration approved everybody. So we'll see what happens. We'll keep everybody apprised on that.
I had one thing I wanted to just also add before we close. So we've talked in the past that we're planning on doing a fee case where we're trying to get fee refunds from the State Department. So I will hopefully today, Jeff Forney and James Hollis and I have been working on a questionnaire form to basically do research to figure out more, to just do fact gathering to figure out more before we proceed with that case. There's a Google form. I'm going to post a link, hopefully today, on Twitter and maybe a couple other places. So if you guys also, Chuck and Jesse and Aaron, if you can push that out a little bit. Jeff and I, we want to gather more information and figure out where the, get a lot more specific examples of harms people are suffering. So be on the lookout for that link. But basically, we're looking for people that either paid visa fees and didn't actually get and get an interview, or get the not people that didn't get the decision that they wanted, but people that never actually got to the point of making a decision. DV 2021 people who weren't in the suits, that basically paid for a service that they never had an opportunity to get. But you'll see when you see this form what we're looking at as far as examples. We're looking for, we're not asking people to sign up for the case. We're just trying to get, and you actually, if you don't want to put your name or your email address in the form, that's fine. We just are trying to do research to learn more about the kinds of problems people have experienced, and maybe other examples that we didn't spot ourselves of how fees were taken for services not delivered. Great. So be on the lookout for that.
Kind of like Ukrainian EADs, which we may be getting back to you on.
That could be in that case.
All right, everybody. It's been great to be with you. Jesse, have a wonderful day. Have a very safe trip. Aaron and Greg, we'll see you guys soon. And we'll see everybody back here next Tuesday at noon. Bye-bye.
Al.